Oh, I'm sorry. I thought we...
I beg your pardon. Senator Hirono, you're recognized. Thank you.
Senator Leahy. And any time that I do not use of my 16 minutes, I would like to have that time go to Senator Booker. Judge Kavanaugh, as you know, this June the court delivered a blow to millions of public sector workers with its decision in Janus versus AFSCME. In a 5-4 decision, 5 of the justices overturned decades-old precedent, a case called Abood, that workers around the country depended on for fair salaries and basic rights. The Janus decision is important here because it shows how your nomination fits in a larger campaign that groups like the Federalist Society and the Heritage Foundation have been waging for decades. Their goal is to undermine well-established Supreme Court precedent that protects workers, women, and everyday Americans. In Janus, 5 justices overturned Abood, quote, because they wanted to, end quote. Those were Justice Kagan's words, not mine. Although the 5 justices went through the factors that for overturning precedent, it identified another, what they referred to as very strong reason for not following precedent, and that reason was, quote, fundamental free speech rights are at stake. In fact, the 5 justices said the rule for following precedent, also known as stare decisis, applies with perhaps least force of all to decisions that wrongly deny First Amendment rights. So it sounds as though the court is saying that First Amendment rights takes precedence. So why is this important? It's because of the larger political campaign by groups like the Federalist Society and the Heritage Foundation that I mentioned earlier. So with the help of these groups, the Supreme Court, as Justice Kagan put it, has been, quote, weaponizing the First Amendment in a way that unleashes judges now and in the future to intervene in economic and regulatory policy, end quote. And in fact, just this past year, the First Amendment was used to advance a political agenda against workers and women's health and reproductive rights. Judge Kavanaugh, do you agree with the 5 justices in Janus?
Senator, that's a precedent of the court that, of course, because it's one of the recent cases, I can't comment on whether I agree or disagree with it, but it's a precedent that is now part of the body of the Supreme Court case law.
And of course, as should you get on the Supreme Court, you can either follow that precedent or overturn it. But basically, the court in Janus said that they came up with a very strong reason for overturning even decades-old precedent if First Amendment rights are at stake. So based on the answer you just gave me, then that kind of rationale would also be the precedent of the court now. So the Supreme Court sets precedent, of course, and all it takes is 5 votes to overturn precedent, as happened in Janus, 5 votes. And I'm particularly troubled that the 5 justices in Janus claimed it did not matter that public sector unions had relied on the Abood case for decades. And yesterday, when you talked about the role of precedent, you talked about, you used words such as how people rely on the precedent, whether it creates stability, there's predictability. But the 5 justices in Janus, the fact that public sector unions have been relying on the Abood decision for 41 years didn't matter. So 5 justices also claimed that they could overturn Abood as well as a well-established precedent because public sector unions were on notice. This is quoting the court. Notice for years regarding this court's misgivings about the Abood case. But as Justice Kagan explained, this so-called notice was actually Justice Alito's 6-year campaign to reverse Abood. So I won't go over his 6-year campaign, but suffice to say that Justice Alito made it very plain to potential litigants out there who wanted to undo the Abood decision. Basically, he said, come on over, because I want to be in a position to be able to reverse Abood. And the only reason in an early case called Frederick said that Abood was not overturned was because of the death of Justice Alito. And then after that, Justice Gorsuch was confirmed, and Justice Gorsuch was going to provide the 5th vote. whereas in the previous vote, because of the death of Justice Scalia, the earlier case of Fredericks ended in a 4-4 tie. But then along comes Justice Gorsuch, and the fifth vote was there, and Abood is overturned, and Janus is now the precedent case. So to the extent that court in Janus said, well, you know, by the way, all you litigants all you people out there who are relying on this precedent, you had notice that we were thinking of overturning this case. So do you believe that a justice should be able to make it easier to overturn even well-established Supreme Court precedent by simply giving notice that he or she has concerns about that precedent? Because that is exactly what Justice Alito did.
Senator, I think the factors that the court considers is whether the prior decision was grievously wrong, whether it's deeply inconsistent with subsequent precedent that's developed around it, the real-world consequences, the workability of the decision, as well as reliance interest.
Well, on the other hand, Judge Kavanaugh, how can you call a 5-4 decision as reflective of the prior decision having been grievously wrong? Not to mention that in the case that came before Janus, ended in a 4-4 tie because of the death of Justice Scalia. So by one vote, the court looked to the notice provided by a justice as one of the justifications for overturning this 41-year-old precedent. So my next question is, do you think the prior writings of someone before becoming a Supreme Court justice can count as notice that Americans cannot rely on the protections entrenched in well-established precedent? If, for example, someone like you did some writing that questioned a precedent, would that suffice as notice for the Supreme Court to overturn precedent?
Senator, I think the factors that the Supreme Court considers in applying stare decisis are established. You look at the prior decision, whether it's grievously wrong, deeply inconsistent with subsequent precedent, the real-world consequences, and the reliance interests. And I understand that you disagree with how those factors were applied, and Justice Kagan, of course, in dissent, disagreed with how they were applied. And I understand.
It was a very strong decision. It was a split decision, and suddenly we're talking about strong reasons being the First Amendment rights, which Justice Kagan said is now being weaponized, and you can see the trend of the 5-4 decisions that weaponizes First Amendment. We're already seeing that. The court said that where the First Amendment rights are concerned, that stare decisis, meaning precedent, applies with the least force. Going on. So basically, the concern I have about the reasoning in the Janus court is that we will see many more 5-4 decisions where precedent can be overturned if a justice has given notice, as Justice Alito did, or if a First Amendment rights are concerned. Let me turn to the issue of guns. You were asked some questions about this, about your position on basically Heller 2. The Brennan Center for Justice reported that as of August 20th, 2018, outside groups had spent almost $3.5 million to campaign for your confirmation, and I think we've all seen those ads. By contrast, groups opposing your nomination had spent less than a quarter of that amount. And one of those groups spending hundreds of thousands of dollars to get you confirmed to the Supreme Court is the National Rifle Association. And the NRA makes clear in their commercials what's at stake with your nomination. In fact, they highlight that there are currently 4 justices who favor gun control and 4 justices who oppose gun control. They then explain, and I'm quoting their ad, President Trump chose Brett Kavanaugh to break the tie. They urge your confirmation, pointing out that the viewer's access to guns depends on your vote, Justice Kavanaugh. So you had mentioned earlier that the Supreme Court had in the past said concealed weapons, guns in schools, machine guns could be banned, but you can provide that 5th vote to undo these earlier Supreme Court precedents. So why do you think, so this is part of their ad, your right to self-defense depends on this vote. This is based on, it's part of the NRA's $1 million campaign to get you onto the court. Why do you think the NRA is spending so much money to ensure that you get confirmed as a Supreme Court justice?
Senator, there are a lot of ads for and against me, and I've seen a
Well,
lot
I'm
of...
asking specifically about the NRA ad. Why do they think you are going to provide the crucial fifth vote to, they obviously think that you're on their page.
Senator, there are a lot of ads by groups against and for. That's the right of people to express their views. I understand that, against and for. And I'm an independent judge, and I, for 12 years, have a record of being an independent judge.
Well, obviously, the NRA does not think you're so independent when it comes to gun legislation because they are spending a lot of money to tell everybody that you are going to provide that crucial vote to their liking. So, you know, I think these ads speak for themselves, why they think you are the critical person to be on that court. Now, I want to follow up one more thing, something you told Senator Feinstein yesterday regarding your views on guns. You seem to indicate that your view of Supreme Court precedent is that a type of gun could not be banned, and I'll quote you here what you said yesterday, if a type of firearm is widely owned in the United States. So did you mean to say widely owned as opposed to widely used in your response to Senator Feinstein?
I think I referred to the dangerous and unusual test that the Supreme Court has articulated and referred to how I'd applied that test in the my Heller opinion.
Well, you did say that if a type of firearm is widely owned in the United States, you would deem any limitation on widely owned guns to be unconstitutional. So is it your view that if a large enough number of people downloaded designs for 3D guns and printed them, and therefore they own them, that the states and the federal government could not ban them? Because now they're widely owned.
Senator, I can't talk about a hypothetical case.
I think that's another reason that the NRA is so adamant that you get on the court. I'd like to see the rest of my time too, Senator Booker.
I understand, Senator Blumenthal, do you have a unanimous consent request to offer some documents?